Okay, statute of frauds. Only what we covered in contracts, so this is not all-inclusive by any means. So you're going to ask two questions. Is the contract within the statute of frauds? Has the statute of frauds been satisfied? So this is Restatement 110, classes of contracts covered by the statute of frauds. The following classes of contracts are subject to a statute, commonly called the statute of frauds, forbidding enforcement unless there is a written memorandum or applicable exception. So what is covered by the statute of frauds is a contract of an executor or administrator to answer for duty of his descendant, wills, and trusts. A contract to answer for the duty of another. This is, a contract made under consideration of marriage. So, and now the two that we're really focused on, a contract for the sale of an interest in land, the land contract provision, a contract that is not performed within 1 year from the making thereof. So I'm guessing on the exam it's going to be a lot more of that 1 year than anything else. So, Restatement 131, general requisites of a memorandum. Unless additional requirements are prescribed by the particular statute, a contract within the statute of frauds is enforceable if it is evidenced by any writing, signed by, or on behalf of the party to be charged. So, in a perfect world, everyone would sign things. Great. But really, it is the plaintiff bringing a suit against the defendant, and the plaintiff has to have the signature of the defendant in order to charge them, to do the cause of act, to do what they want them to do. And the writing must reasonably identify the subject matter of the contract, is sufficient to indicate that a contract with respect thereto has been made between the parties or offered by the signer to the other party, and states with reasonable certainty the essential terms of the unperformed promises in the contract. So it's got to have some oomph, this is what we're agreeing to. And then Restatement 134 governs the signature. And then the signature of a memorandum may be any symbol made or adopted with an intention, actual or apparent, to authenticate the writing as that of the signer. Courts are still working on the application of this rule to modern forms of communication, fax, email, text. States can adopt statutes to deal with other such modern forms of technology. So the Restatement 133 is about pleadings and testimony. And it says a written pleading, stipulation, or deposition may serve as a memorandum if otherwise sufficient as to contents and signature. An oral statement before the court is treated in some states as the equivalent of a signed writing. And the Uniform Commercial Code 22013B and 8319D says where writing or oral statement is made under legal compulsion, it is nonetheless effective unless there is a contrary procedural policy in the state. So those are some ways around the signature. Restatement 130, contract not to be performed within a year. So this is one we spent kind of our focus on, where any promise in a contract cannot be fully performed within a year from the time the contract is made. All promises in the contract are within the statute of frauds until one party to the contract completes its performance. So it cannot be performed within a year. All promises in the contract are within the statute of frauds. When one party to a contract has completed his performance, the 1 year provision of the statute does not prevent enforcement of the promises of the other parties. So the 1 year provision, within a year, a contract is not subject to the statute of frauds if it is possible to be performed within a year, even though the prospect of such performance is remote. So if it is when I die, I'm going to give you my jacket. Well, I could die within the year, and therefore, no statute of frauds. Lifetime contracts. Most courts hold they do not fall within the statute of frauds, although you can have some pushback, which is the exact type of I just gave you. Restatement 130, comment C, the rationale. The primary purpose of the statute is evidentiary, to require reliable evidence of the existence and terms of a contract and to prevent enforcement through fraud or perjury of contracts never, in fact, made. And then the Restatement 130, comment A, says the design was said to be not to trust the memory of witnesses for a longer time than 1 year. And then some of our other hypos, is it cautionary? Consider the contracts included in the statute of frauds. Does it actually work? So here's some like back and forth. Some do, some don't. Evidentiary. A promises B to employ B for 2 years starting tomorrow. 3 days later, A terminates B. This is within the statute of frauds because there is no way he could be employed for 2 years and be done within a year. A promises to paint B's house for $1,000 within the next 5 years. A fails to do so. At the end of 5 years, B sues A for breach of contract. This is not within the statute of frauds because he could do it from now until 5 years from now, so he could have essentially finished the contract before the 5 years and essentially was used well there. So Helfand, you don't get to say it wasn't. Cautionary, because this is my video too. Cautionary for significant contracts. Okay, A promises B to employ B for 11 months, starting tomorrow. 3 days later, A terminates B. Not within the statute of frauds because he could definitely finish within 1 year because he was only going to be employed for 11 months. A promises B to employ B for 1 day, starting in 13 months. A fails to do so, B sues for breach. This is within the statute of frauds because even though he was only going to be employed for 1 day, it's 13 months away. So he could not finish that before the year was up. Part performance exception. A court of equity therefore requires that a part performance relied on to take the cases out of the statute of frauds should be of a character not only consistent with the reasonable presumption that what was done in the faith of such a contract, but also that it would be unreasonable to presume that it was done on any other theory. So defendant, part performance must be unequivocally referable to the contract. Plaintiff, part performance would naturally and reasonably lead to conclusion that there was an oral agreement. And this is Beaver v. Brumlow, sold land to employee and his wife, and then he went to the competitor. So they didn't have a writing, and they said, you know what, your conduct showed part performance. We learned in property that it's money, taking possession, and making valuable permanent improvements. And you needed 2 of those at least. And so it's kind of the same here, but we don't have actually paying for it here. So the court's conclusion in Beaver v. Brumlow was we did not say that the performance must relate exclusively to the oral contract. Rather, the performance must lead an outsider to naturally and reasonably conclude that the contract alleged actually exists. So 2 key specific factors approved by this court and many others in coming to this conclusion are taking possession of the property and making valuable, permanent, and substantial improvements to the property. Where these 2 factors coincide, specific performance usually results because it satisfied what we normally require from a contract. Restatement 129, action in reliance, specific performance. A contract for the transfer of an interest in land may be specifically enforced, notwithstanding failure to comply with the statute of frauds, if it is established that the party seeking enforcement in reasonable reliance on the contract and on the continuing assent of the party against whom enforcement is sought has so changed his position that injustice can be avoided only by specific enforcement. Courts with equitable powers are vested by tradition with what in substance is dispensing power based on the promisee's reliance, a discretion to be exercised with caution in light of all the circumstances. So land is considered unique, so specific performance is often done there. As always, I'm running out of battery. So we're going to move you over a little. We're almost done with this one. Statute of frauds and reliance. Different types of reliance linked up with different types of contracts. So a contract for the sale of land, you're going to look for part performance. A contract that is not to be performed within a year, there is no part performance exception to contracts that cannot be performed within 1 year, because the exception would destroy the rule. That's why we have a rule, because it's so far out, it's evidentiary. But we can use promissory estoppel. So a promise that should induce reliance that actually does reduce reliance that only justice could fix. And therefore, justice requires that it be fixed as well. The UCC adds contracts for more than $500. Anytime UCC is silent, we are to incorporate the common law rule. Restatement 139, enforcement by virtue of action and reliance, which is what we just said. Promise, which the promisor should reasonably expect to induce action or forbearance on the part of the promisee or a third person, which does induce the action or forbearance, is enforceable notwithstanding the statute of frauds. If injustice can be avoided only by enforcement of the promise, the remedy granted for breach is to be limited as justice so requires. And this would be Alaska Democratic Party v. Rice, holding defendant liable for damages flowing from breach of oral contract, even though the contract could not have been performed within 1 year. This is because Rice relied on Wakefield's promise in accordance with Restatement 139. Does promissory estoppel render the statute of frauds superfluous? No, but plaintiff's burden is to establish the promise's existence by clear and convincing evidence. Restatement first of contracts, only when plaintiff relies on defendant's misrepresentation that a writing had been created, plaintiff relied on promise that a memorandum would have been created. So it's a little different that when they're like, oh, like we have this writing and we're going to put it together for you, but then they don't. So then there's we're showing some misrepresentation. And then the restatement second of contract says promissory estoppel to reasonable reliance on an oral contract. Some courts still refuse to recognize the applicability of promissory estoppel to the statute of frauds. This is another example of the trend towards limiting the effect of the statute of frauds. So I'm going to look a little more closely at that because I don't feel like I had any notes on it. And that is that for this. Thank you.